Welcome to the 2025 Cal OSHA webinar series. Our latest series edition today is the Cal OSHA mid-year update, and we are joined today by myself. I am Rachel Conn. I'm a partner and chair of Conn Maciel's California practice, and I am based here in the San Francisco office. And I do everything OSHA related with a specialty in Cal OSHA, and that includes inspections, audits, investigations, enforcement actions. I'm also joined today by my partner, Megan Shaked, who is also here in the San Francisco office with me, who also represents employers in all Cal OSHA matters and labor and employment matters. In our Southern California offices, we have Andrea Chavez, who is senior counsel and also focuses on Cal OSHA, labor law, and employment law. And in addition, Sam Rose, who also does all things OSHA and employment law as well. So welcome to our webinar. And for today's agenda, we are going to focus on Cal OSHA rulemaking and enforcement priorities. Cal OSHA, as we know, is always aggressive when it comes to rulemaking and continues to do so. We've recently just received 3 draft revisions to various rules that we will go over in detail today. We'll go over the staffing and enforcement priorities, so what we've seen, what we should continue to expect. We'll talk a little bit about the NIOSH updates at the federal level and how it is affecting everyone at the state level, and in particular here in California, what the California Standards Board has been looking at when it comes to NIOSH. So, and we've seen some back and forth about what's been going on at the federal level, so we'll talk about that as well. We'll also go into the legislative updates for California and recent appeal board updates and decisions. So with that, we'll just jump into enforcement priorities. And if you have questions for us, feel free to leave them in the chat. We will try to get them as we go through this, and we'll try to save some time at the end to also address them. But of course, if we aren't able to get to your question during this presentation, you can always feel free to reach out to any of us, and we're happy to answer that question afterwards as well. So enforcement. Cal OSHA staffing, that has been a very big topic of discussion both at Cal OSHA, outside of Cal OSHA. If you've been to any of our webinar series within the past year, we talk about it, we continue to talk about it. Staffing levels have been quite low at Cal OSHA for a very long time. They have put several different mechanisms in place to continue to increase staffing, and that's at all levels. We see it. We see it at legal, we see it at district managers, we see it at the COSHO level. And so there is a continued increased emphasis on Cal OSHA's part and the Department of Industrial Relations, which Cal OSHA rolls up to increase staffing. So what does that mean? That means that we see and have seen an increase in inspectors, but some inspectors that don't have the same level of experience or sometimes the same level of knowledge when it comes to the regulations. So what that will mean is that if you have an inspection and you have a new inspector that is conducting that inspection, you certainly want to be making sure that you're paying closer attention to that and to what is going on with it, because they may not be fully versed yet in everything when it comes to procedures and regulations. So you want to make sure that you're certainly keeping an eye on that. Give us a call. We're happy to help you with that as well. BOI, which is the Bureau of Investigation, that is a separate unit in Cal OSHA. So it's separate from the enforcement unit. We put it under enforcement, but it's technically a separate unit, and their job is to review incidents to determine whether or not it is appropriate to make a referral to a prosecutorial agency based on their investigation and the facts that they gather. And they have a 3-year statute of limitations to do that. And we've talked about this on our webinars before, but as of last year, they had been down to only one investigator in the state. They are now back up to full capacity. So one, we anticipate seeing more BOI investigations, and we have seen that in practice as well. And we expect once something is subject to a BOI investigation, that does stay the underlying appeal. So we also have been seeing accordingly more appeals being stayed subject to BOI. And of course, that can get a little tricky because what's actually stayed is the hearing. But we've seen Cal OSHA Legal continue to press forward with things like discovery and pushing for abatements and things like that. And you certainly want to, if you are part of a BOI investigation, you certainly want to talk to your counsel about that, because things that are produced during the underlying Cal OSHA appeal and matter may be used in the BOI investigation. So what you're producing, discovery, things like that, you certainly want to discuss with counsel so you ensure that you are not affecting your BOI investigation. And we're happy to talk through that with you if you want to talk about additional strategies around that. Inspections. So this is an update on some of the inspections that we have been seeing by subject. Silica, they've had 102 inspections opened since 2024. 83 have resulted in violations being issued. And for bird flu, which we know has been affecting the different industries, in California, we've seen 60 inspections, but only 2 had violations issued under the ATD zoonotic standard, which is a separate standard than the regular ATD regulation. Indoor heat, which went into effect in July of 2024. Already, we've seen 329 inspections. That's not even a full year of having that regulation in effect. So that's quite significant, and it has resulted in 66 violations issued. As somebody, or I think all of us on this a webinar today have been a part of indoor heat investigations, whether it be accident related or complaint related, and they are quite intensive and they are quite also extensive. So Cal OSHA really does throw a lot of resources at them. So it is certainly, as we're starting to get into the warmer months, make sure your indoor and outdoor heat illness plans, trainings, controls are in place, because we know that this will continue to be an emphasis area for Cal OSHA. And certainly these numbers of inspections that we're seeing, that confirms what we've already been seeing in our own work. And Andrea is going to talk a little bit about indoor heat and outdoor heat are 2 of the regulations that have revisions, draft revisions out. So we may see some additional revisions to both of those regulations. I know some folks are saying we just had indoor heat rollout and now we're potentially seeing new regulation or new revisions to that regulation. And we'll talk about that a little later in a minute. So jumping into rulemaking, the Cal OSHA Advisory Committee meetings, They just released these not too long ago. So these are the general main advisory committee meetings. One is tomorrow. So we will provide an update on that meeting, probably in a blog in the next week or so. And then, of course, there's the subject matter advisory committee meetings. And here is the list of the ones that the different regulations that are subject to the subject matter advisory committee meetings that will be taking place periodically throughout the year. One note about workplace violence. As part of SB 553, there were revisions to the workplace violence restraining order statute and to allow unions to go in and petition for a workplace violence restraining order on behalf of employees. And that was delayed past the when SB 553 went into effect for the plans and trainings, and that's because the Judicial Council had to update those forms. Those forms have now been updated, so you may see, if you are part of a unionized workforce, you may see potential workplace violence restraining orders filled out by the union because those are now up and available and running. And speaking of workplace violence, that is one of the regulations that has a revised draft has been recently been released as of last week. And this is the second draft that they've released. We had one earlier, and now they had additional comments. And this is the draft based on those additional comments. So we're not going to go through all of the comments or the revisions, but here are kind of the main ones that we want to flag. And that now the comment period is open for this draft. So this is not the final, but these are the new revisions and may continue to be subject to change. So the first one is in the scope, and if you've read it, you follow this, one of the exceptions to having a workplace violence prevention program and being subject to the reg is that if you had your facility was not open to the public and you had less than 10 employees and you were in compliance with the IIPP. Well, they've revised that slightly, and now it has less than a total of 10 employees. And the reason why they changed that language is because they didn't want a fluctuation in applicability depending on whether today there's 5 employees, tomorrow there's 11 employees. So they're looking at the total number of employees on payroll to make that a more stable measurement. They've also included that this exception does not apply to security services, janitorial services, and domestic workers pursuant to the definition under the labor code. And that's because they believe that these industries are more vulnerable to workplace violence. Also, one of the big questions when we were developing workplace violence programs and compliance was who is an authorized employee representative? That wasn't previously defined in the statute. They've now defined it, and it means an organization that has a collective bargaining relationship with an employer or an organization acknowledged by a public agency as representing its employees. So certainly that narrows down what the potential for an authorized employee representative may mean. And so that will, I think, certainly help people when developing plans and implementing plans moving forward, if this is the definition that remains. Engineering controls, they did make a modification before. They just had this list of engineering controls, and it was unclear based on the language that did employers have to implement all of these engineering controls. They've now clarified that these are just examples and should only be included if applicable. So it's not required to be implemented at every workplace. They've also noted that for threat of violence, that the employer is not responsible for employees' texts, electronic messages, or personal social media not brought to the attention of the employer, or that the employer could not otherwise reasonably be aware of. There was a lot of concern about, what was an employer's obligation to be policing employee texts or social media or things like that. So this clarifies that a little bit more. It also includes in workplace violence that the crime of stalking is included as part of workplace violence. And then for effective procedures, it clarifies that employers shall ensure that reports can be made in a manner that does not discourage reporting, and to a designated person that is not a direct supervisor for type 3 violence, which is employee to employee violence. So this one is a clarification, but I don't think it will operationally make too much difference in your plans and operations. And then this is one that I know a lot of folks had concerns about, and I'm glad to see that they've revised it here, and that is the offering or making available individual trauma counseling when there's been a workplace violence incident. So a couple things that they've clarified further here is that, first of all, they've taken it out that it's for employers with more than 25 employees, but they've clarified that one, the offering or making available is upon request, and two, that the trauma counseling offered to the employee through workers' comp would be sufficient, and also any counseling or treatment offered through employee assistance programs, EAPs. That was a big question that I know a lot of us had and employers had, because many employers have that available to their company and to their employees. And so we certainly wanted to ensure that qualified under this additional requirement. And with that, I will turn it over to Andrea to get into some the additions to, or draft additions to, California heat illness regulations.
Thanks, Rachel. So on May 7th, OSHA released draft proposals to amend the outdoor and indoor heat illness prevention regulations, with public comments being due July 7th. So the first proposed revision I'm going to go over is the one that I actually think is needed. In outdoor work areas, the current regulation requires close observation of employees newly assigned to high heat areas. And we get a lot of questions on what high heat areas actually mean. And I think you can make a reasonable assumption, that the version would officially align the existing high heat threshold in section E with the definition of high heat area. The proposal also introduces new acclimatization requirements for outdoor employees when the temperature is 80 degrees Fahrenheit or higher. So under these circumstances, employers would be required to either implement the high heat procedures found in section E for 5 days, meaning ensuring that there's effective communication, observing employees, doing those pre-shift meetings, or adopt a phased acclimatization schedule for new employees. And that is modeled after the Fed OSHA proposed heat rule. And it would be 20% exposure on the first day, 40% on the second, 60 on the third, and then 80 and then 100. For current employees returning after a break that's longer than 14 days, acclimatization would be limited to a phased approach, but only for 3 days. And that would be 50% exposure, then 60, then 80. So the phased acclimatization requirement would not apply if the employer can demonstrate that the employee had consistently worked under similar heat conditions within the past 14 days. And this exemption is from Fed OSHA, And in the notice of proposed rulemaking, it makes clear that in determining whether the employee worked under similar heat conditions, an employer would have to take into account the level of exertion in their prior tasks compared to their current tasks. And they give the example of picking tomatoes versus picking watermelons. And in their opinion, that would not be considered similar tasks because the watermelons are much heavier than tomatoes. So although this exemption exists, I do think it's going to be pretty narrow when actually applied. In indoor workplaces, new or returning employees can either be acclimatized in a phased approach, which is the same as the one we just went over for outdoor workplaces, or they can implement the control measures currently required under Section E2 with the exemption of engineering controls, meaning that the employers could would have to implement the administrative controls and the personal heat protective equipment requirements. And then the indoor employees also have the same exemption if they worked under similar conditions under the past 14 days. So the regulations in both indoor and outdoor currently require that the plan be made available to employees, and the revision would clarify that the plan must be distributed to new employees upon hire, during heat illness prevention training, and to every employee at least once a year, and that the distribution would not be required more than twice a year. It also states, although not actually in the plan, but under the guidance in the current draft, that electronic distribution would be permitted for employees able to receive electronic copies. Okay, so Cal OSHA has also published proposed revisions to the wildfire smoke regulation. In it, the air quality index table would be revised to indicate that a PM 2.5 level of 103 or above would be considered hazardous. It also clarifies when employers must provide respirators to employees. So they would be required to provide respirators, but not require their use, where the current AQI for PM 2.5 is equal or greater than 151, but does not exceed 300 for agricultural employers or 500 for all other employers. And when the AQI exceeds these amounts, that's when the respiratory protection becomes mandatory. But a written program and fit testing is only required when the AQI exceeds 500, regardless of industry. Okay, and then in response to the recent LA fires, the DIR posted guidance for employers and workers on how to, proceed safely as they work through the debris and conduct cleanup. So they noted from a safety standpoint, possible physical hazards like the risk of collapsing structures or dealing with live electrical wires. They also noted that HAZCOM is something to consider. Fires often release hazardous chemicals such as lead or asbestos. And they noted that the debris cleanup has to be done in accordance with the hazardous waste operations and emergency response regulations. And cleanup is also these types of emergencies in general, not just the cleanup, are also a crossover issue. So with employment laws, for example, it's illegal for employers to require workers to report to work if they have a reasonable belief it isn't safe. Employers can't, prevent workers from using their phones during emergencies. Time off is a big issue. So time off generally does not need to be paid, but for agricultural employees, they can use paid sick leave during emergencies with smoke, heat, or flooding. Also, taking time off for something like smoke could be considered preventative care or care for existing health condition, in which case employees would be entitled to use paid sick leave. There's other leave laws that should also be considered when dealing with these natural disasters. So yeah, there's a lot to consider when dealing with natural disasters, both from a safety point of view and an employment point of view.
Thanks, Andrea. So another set of regulations that's working through rulemaking is on the enterprise-wide and egregious violations. So back in 2021, Governor Newsom signed SB 606, which made changes to the labor code. And this allowed for created an egregious classification as well as an enterprise-wide violation. And so those exist in the labor code currently. And the next couple of slides will give you, and we'll stay on this slide for now, but the next couple of slides will give you the summary of the information that lives in the labor code. But now what is happening is that Cal OSHA is working on a corresponding regulation. And while the regulation has to be have at least what's in the labor code, there is some flexibility for the agency to include some additional language in the regulation to clarify the requirements or even adjust the requirements so long as they're still in line with what the labor code requires. So on this first slide, you'll see the beginning, and it continues to the next slide of the what classifies as an egregious violation. So it's something that is willful plus, a violation that is willful plus egregious in the last 5 years, or one or more of the following conditions. And there's a whole bunch of them. These are the things that can rise to the level of an egregious violation. The agency can choose to cite egregious. So it's kind of, we think of it as willful plus. It has to have some enhanced feature from this list, this numerical list, to be eligible for that classification. And we've gone over this a few times, so I'll save the time for the update on the regulatory front. But if you go to the next slide, this is the explanation about the enterprise-wide, that the labor code again provides for a rebuttable presumption that a violation is enterprise-wide under certain conditions. One is where an employer has a written policy or procedure that violates health and safety code or the labor code, or the division finds evidence of a pattern or practice of the same violation, including more than one employer's work site. So then moving on to the next slide, the process that the division has been going through so far has been what we call informal rulemaking. So they had an advisory meeting in August of last year. They proposed regulatory text and gave stakeholders an opportunity to go through section by section, ask questions, make suggestions for improvements. And then a couple of months ago, they had a second meeting to go through the revised text. They accepted comments on the revised text through April 8th. And they anticipate beginning the formal rulemaking process this fall with a hearing by the end of the year. So right now they've been kind of going through the drafts, getting feedback, but at some point they will trigger what's known as the formal rulemaking process. There will again be an opportunity for notice and comment, though that will happen through the standards board meetings rather than through these advisory meetings. So on the next page, I've highlighted just a few of the changes in the version that was discussed at the March meeting. Just note that the next version that comes out may be a little bit different than the current draft. So certainly if this is an area of interest, we can provide a copy of that current draft, but it is anticipated to change. One thing I wanted to note under the egregious classification is that they clarified there were certain kind of history of violations that could trigger, and one of them was having a single serious on your record. And for employers of a certain size or certain history who've been around for a long time, that folks explained during the advisory committee process that seemed like a very low threshold. So they've changed that in the current version to 5 or more per 100 employees. There's another change to the enterprise-wide violation where they clarified a few moments ago I mentioned that there are two triggers that could make somebody eligible for an enterprise-wide violation. So they've clarified the first trigger, and the language is there. And there have been some other clarifications in the draft language where they've tried to hear the questions and the concerns that the stakeholders have raised and try to provide examples in the regulatory language and other clarifying language. Just another example of how participation in the informal rulemaking process can bring some changes to the regulation that then gets proposed in the formal rulemaking process. Moving to the next slide, just a couple other takeaways from the March 2025 meeting. There were questions about, how is the division going to decide if they're going to how they're going to issue the penalty on an enterprise-wide violation. And the answer was it's really in the discretion of the inspector, the COSHA, and division management how to decide on the penalty amount. Obviously within the limits of what the regulation calls for. They also heard a lot of comments about the potential impact on small employers and how adjustments might be made accordingly. And then they did keep coming back to the author's intent to address the lower numbers of inspectors as compared to the large number of employers in the state, and how the availability of issuing an enterprise-wide violation would be a tool for the division to address violations they might discover at one work site to be able to get compliance at all non-compliant California work sites. Just one brief update on lead. I know we've spoken the last couple of updates about the big change to the lead regulations. OSHA did issue revised guidance in May, so earlier this month. So if lead applies to you, you'll want to make sure to take a look at that guidance to see if it helps with compliance at all. Those changes went into effect January 1, 2025.
Thanks, Megan, for those updates. We wanted to give a brief update on what's going on over at NIOSH. A lot of you might have seen, if you're tuning into the Cal OSHA Standards Board meetings or just the news in general, that NIOSH has been at the center of a lot of DOJ news. So we wanted to just cover that and kind of give you an update on where that's going. So just some brief background. NIOSH is an agency that was established by the OSH Act. It's actually under HHS and CDC, not part of OSHA, but NIOSH conducts a ton of research related to occupational safety and health. And so it's a very key aspect to what OSHA and in turn Cal OSHA drafts its regulations based on, and a lot of Cal OSHA regulations incorporate NIOSH or other agency recommendations into their regulations. And so it can impact what employers are required to comply with in the state. In April, there was a huge cut to the staffing at NIOSH. Over 2/3 of the staff was let go as part of restructuring at HHS. That restructuring was based in part on the overhaul of health agencies of the federal government, and NIOSH eventually became part of that restructuring. Since then, actually last week, so a little bit of breaking news, if you want to call it, HHS has reinstated the director of NIOSH and reinstated 300 of those 800 employees that were let go. It's also restored key programs, the ones that are listed here: Respiratory Health Division, Division of Safety Research, Division of Compensation and Analysis Support, and the National Personal Protective Technology Lab. That last one is important because that's the division at NIOSH that certifies respirators. And as some of you may know, the firefighter standards in California require that their PPE and their respirators be certified by NIOSH. So the Standards Board had, in previous meetings, confronted the idea that maybe there would have to be revisions to that standard because NIOSH, the viability of NIOSH was in question at that time. So it's still not a done deal that NIOSH will be fully funded, as there's still 500 or so employees that have not been brought back. But at least for now, it seems like NIOSH is going to continue at least this aspect of firefighter PPE certification and some other divisions within the agency. But obviously, this is all subject to change going forward, depending upon how the federal government staffs and funds the agency. This is just a brief slide on what would happen if NIOSH was severely cut, or if there was additional layoffs over at the agency. There would be a lot of critical research related to safety and health that would be cut, and that would not be available to either OSHA or employers. And then there would be disruptions to in-workplace outbreak investigations because NIOSH is involved in those. A lot of states, and since this is a Cal OSHA webinar, we'll focus on California, have been contemplating how they're going to react or respond to the federal government's cutting of NIOSH funding and staffing. In the last standards board meeting this week, I think it was this week or last week, they are talking about creating a subcommittee within the standards board that would evaluate how California, at least the standards board, will respond to these. So that's one example of how California and the standards board and Cal OSHA are responding to these federal changes. So we'll continue to watch the NIOSH trajectory and provide updates on where that goes. But next we'll turn to the appeals board update and some cases that have come out from the Cal OSHA Appeals Board recently. So the first topic, we kind of have them organized by topic, and there's citations to the cases in the slides if anybody wants to go online and pull those up. But the appeals board continues to hold that late appeals will almost never be allowed. This first one is a recent case, but it's kind of a long-standing precedent of the board that an employer's misunderstanding of the appeal process or confusing deadlines within the appeal process is not good cause for a late appeal, and so that will not reinstate the employer's appeal for untimeliness. This second one is a little bit of an interesting facts. In this case, Michael Muharib, the employer timely filed an appeal, and that same day that the appeal was filed, the board sent a notice of incomplete appeal to the employer stating that there was information that was missing, and so the appeal was not going to be considered complete. And it gave the employer 20 days to respond to the notice and provide the necessary information. The employer didn't respond to that notice, and so the board dismissed the appeal, and the appeals board upheld that dismissal. So just an example of the board finding ways to dismiss appeals. This was a timely filed appeal. The citations were issued, and the employer complied with that 15 working day deadline. But because of its failure to respond to a later notice of the appeals board, that appeal was dismissed. So just a reminder, if you're handling appeals yourself or if you have counsel, to just make sure that you always pay attention to deadlines that the appeals board provides and make sure that you're complying with those deadlines. The next sort of general topic is amendments. We've seen in recent years huge broadening of the division's ability to amend citations up to and beyond hearing. And in this case, Sutter Bay, which was released in January of this year, the appeals board held that, well, in this case, the division had made multiple motions to amend the citation during the actual hearing, but only the last motion, which was made after the hearing concluded, was granted. And that motion specifically requested that if the ALJ did not find a violation of the original cited subsection, that the citation should be amended to allege 3 other potential subsections. Kind of unfair. It's basically asking the ALJ to say, if you don't find that we proved our case on these, you can also consider these 3 other ones. And this is all done after the hearing. The board upheld those amendments and found that since the amendments were based on the same ABD in the citation, that the employer suffered no prejudice based on those amendments. So this appears to be another example of the board broadening the division's ability to amend these citations, and it's really, going to be on the employers to try and make these prejudice arguments that if amendments are allowed after the employer is no longer permitted to provide evidence or defense of the citations, that's really an unfair position for the employers to be in. But so far, it seems like the appeals board is not entertaining those arguments. The last case that we have on here is a related to consent in an inspection. This case is a really large broadening of what the appeals board is going to consider consent to access your work sites. In this case, the COSHA went to the work site, and the facts in the opinion are kind of vague, and so it's hard to sort of parse out what actually happened. But eventually, the COSHA got in contact with the employer's workers' compensation insurance broker. And that workers' compensation insurance broker essentially told the COSHA that they would work with them to provide the documents and the information that the COSHA was requesting. Later on, the employer argued that conversation or that conduct with the workers' compensation broker did not rise to consent, and so the COSHA would have been required to get a warrant. The board found that the workers' compensation broker's statements and their conduct in going back and forth with the COSHA on the documents and information supported a finding that the workers' compensation broker had authority to consent, even though the employer was not necessarily involved in those conversations. I believe there was a fact that the employer was CC'd on emails between the broker and the COSHA. And then the board went further and said, even if the broker didn't have authority, the COSHA's good faith belief that the broker did was reasonable and based upon good faith. And so the board would have found that that was implied consent, even if the workers' compensation broker didn't actually have authority. So a really broad and kind of concerning decision that really puts your workplaces out of your control to a certain extent. So we'll see what the division and what legal does with this case, and if they try and broaden it even more, but just something to be aware of. So with that, I will turn it back to Megan to provide some updates on bills that are making their way through the legislature.
Thanks, Sam. We're in the home stretch, so we wanted to leave you with a couple of bills out in the California legislature that we're watching. We don't know if they will pass and if they will be signed by the governor, but it's something that we're tracking related to this area. So the first two have to do with AI and automated decision systems. So first, Senate Bill 7. This one, it requires employers to provide specified notice to employees where automated decision systems are being used in the workplace to make employment-related decisions. And for those who may be interested in this topic, we covered it in more detail on our blog, on our employment blog, but the employment-related decision includes things that you would think of on the employment law side, the terms and conditions of employment, and it also includes things like productivity metrics and health and safety. So if AI and automated decision systems are being used in that context, and what exactly that means is a big question mark for these two pieces of legislation, then there's some notice requirements, notifying employees that what the systems are that are being used, if they are used in something that is impacting the terms and conditions of employment, notifying them, and having some other requirements as well. So SB 7 is more specific to the employment-related context. The next bill, which is Assembly Bill 1018, is much broader and kind of applies to all sorts of industries, including employment. This is about, again, those same automated decision systems and where they're used to make consequential decisions, which are those that could materially impact cost, terms, quality, or accessibility of lots of different categories. And one of those categories is employment, and another one of those categories is workplace health and safety. So this is a little bit more, I think of it as kind of, if you're using those systems, this bill is designed to create some guardrails on the use of those systems for impactful decisions. So it calls for a specific number of steps to be taken where folks are covered by the new rules, which again are proposals in the state legislature. And those include things like conducting evaluations of how the automated decision systems are working, providing certain disclosures to employees who are impacted by them, permitting opting out of the use of an automated decision system or the impact that it may have on you, providing an appeal system, including review by a human, as well as submitting to periodic audits. So a similar bill worked its way through the legislature last year and was not successful. So it remains to be seen what will happen with these two, but we are watching those closely.
Once you're done there, I was just going to chime in on one of the issues that's in the federal appropriations bill is that if that bill passes in its current form, which we don't know if it will, that would ban state laws on regulating AI. And so if these laws become law in California, obviously employers in California will need to follow them, but it remains a question whether the federal government is going to refuse to allow states to regulate in this area.
Yeah, there's a little bit of a push and pull. There was a decision at the federal level to, not regulate this area in a way to try to kind of open the gates, allow for innovation, and then there's been a response at some of the state levels, including California, to go in and say, well, maybe we need some guardrails in this area, have some guidelines. There actually were some updates to the regulations that apply in California on the employment law front on this. So California is certainly addressing this issue in a number of different industries. And then the last bill that we are tracking is Assembly Bill 1371. We will continue to track any bill that has anything to do with employment and workplace health and safety, and provide full updates throughout the year and towards the end of the year. I'll talk a little bit more about that in a minute. But this one is certainly already on our radar. So if you recall from a few years ago, there is already in existence some protections when employees feel that they're being asked to work in an unsafe environment, some anti-retaliation protections and protections from being able to not do that work. This is trying to clarify and give a little bit more teeth to those protections. And expand the circumstances under which an employee is essentially protected from performing work in unsafe conditions that they perceive to be unsafe. So this would allow employees, if they're acting in good faith, to refuse to perform a task assigned by an employer if it would violate prescribed safety standards, or if the employee has a reasonable apprehension that the performance of the assigned task would result in an injury or illness to the employee or other employees. The really, really big change here is the proposal for wage continuation. So if somebody is exercising their rights under this law, that they need to maintain, they still need to be paid for their regular work time. There's also, anti-retaliation provisions and provisions for an individual employee to take action. There's also an additional aspect, which is that if the employee communicates or attempts to communicate a risk, and they haven't heard back from the employer, they do not have a response from the employer that allays their concerns, that is still covered by this law. So this is one where we're definitely looking out for. And those are the ones that we have on the radar at the moment. One of the things that we do every year, the legislative session, the calendar session, wraps up at the end of September, and then the governor has an additional 30 days to sign or veto. So we will have a full update for folks at our annual summit, but I'll get to that in a minute. Like Rachel said, if there are questions that we weren't able to get to during the course of the webinar, we will reach out, or feel free to reach out to us individually. And then we wanted to highlight, you can review in the slides all of the events that we have coming up, but we wanted to particularly highlight our in-person opportunities. So we have our webinar series every month, we have our blogs, but we have 2 in-person opportunities coming up. One is in Detroit, Michigan, that's coming up June 5th. And then the event that I think this will now be, is this our 3rd, Rachel? Cal, OSHA, and California Labor and Employment Law Summit. We will do again in Northern California in Berkeley in October 21st, and then in Pasadena on October 23rd. And the timing of that summit is intentional so that we can give you the full legislative update, because by then we know what bills have passed and been signed by the governor, meaning we actually know what the compliance requirements are by that point. So we hope to see many of you there. And again, if you have any questions on anything that we covered today or anything else, please let us know.